first brown bag discussion, let me just give you, welcome you, all of you to the CRC Asia office. As you know, I'm also very new here, but I'm very lucky because I have our colleagues, and we have Manay, also former coordinator of CRC Asia, joining us today. So we're also very happy to welcome Attorney Feli Arroyo. She's our newest member of our board of CRC Asia. And then we'll ask each one of you to introduce yourselves. But for the moment, I just have to explain. The Brown Bag series is designed to inform the CRC Asia staff and our colleagues from the child rights sector about the latest developments, so that we can be more abreast with what's new in the science and what's the different sciences that can help us understand our work to protect children better. So I'm so lucky because I met Cora a few years ago. We were very fortunate. We're both graduates of Philippine Science, and it happened that we were in the same batch of the awardees of Gawad Lagablab. She, for her scientific work, Gawad Lagablab is it's an award to honor alumni of Philippine Science High School. Of course, we're different batches now, used to be. So, the Gawad Lagablab is an award given to Philippine science students who excel in whatever, in different fields of work. And I think I'm one of the first to be awarded for non-science. I forgot to say that protecting children from violence is one of the core issues of CRC Asia. And we're looking at different ways to approach the problem of violence against children. And of course, we value very much our partnership with our fellow NGOs who are working on the front lines to combat violence against children. So we're happy to have Kathy Sherry from Tuluyan, and then we have Melly from ECPAT, Philippines. And then Alice is an old friend from elementary, high school, long-time friend. And she's also working on children's rights. She's been a guidance counselor and now teaching as well in Miriam. And then, of course, we have our friends from Ateneo as well, Ateneo Human Rights Center. Yeah. And then we have we're complete today. We have all our colleagues, our staff from CRC Asia.
First of all, I'd like to say sorry that I was running late. There were some major things that I had to finish before coming here. So that will not be avoided. Anyway, thank you for your patience. And what I've done here is that I've divided the talk into two. Hold up, this is my husband, Attorney Houston. So there is conjugal property here. Conjugal property. Because I thought before going into the actual technology, you need to be able to know how it is applied or how it would benefit your own work. So I thought, I asked him, can I use your set of slides? He gives lectures on DNA evidence. He's a lawyer and the Philippine justice system. So I pulled up some of his slides to be able to make at least an attempt to try to package the whole thing in terms of benefits for your work and relevance for what you do. So the outline of his presentation is, of course, the value of DNA evidence, the rule on DNA evidence, which was already promulgated in 2007 in the Philippines, issues raised against DNA evidence. I think discussions on this would be relevant for your work, what issues had been raised and how they had been addressed by the Supreme Court. DNA evidence, how it has been used in court, etc. So first of all, the value of DNA evidence, and this is, I guess some of you are doing law from Ateneo. Yes, you're doing law. So these are the words of a lawyer. DNA is a powerful investigative tool because, with the exception of identical twins, no two people have the same DNA. So that's really one of the strongest power of DNA. If you've got evidence properly collected at the crime scene, and when we talk about sexual abuse, crime scene is the body of the woman or the child, then that enables the scientists and the investigators to identify the source of non-victim DNA on a child's body. DNA collected from a crime scene can be linked to a suspect or can eliminate a suspect from suspicion. So DNA is one of the objective an objective piece of evidence. That does not side. Again, that's the strongest power. What is the strongest power of DNA? It does not side for the prosecution nor for the defense. It speaks for itself. So we have been able, through the years, to talk to advocacy groups such as women and child groups such as yourselves. At the same time, we have been able to talk to groups like the Free Legal Assistance Group for the defense of those who have been wrongfully convicted. Why? Because DNA only speaks for what is there in the crime scene or the body of the person that had been violated. DNA can be used to determine paternity. In many aspects, paternity are civil cases. However, we've come across some cases which are of criminal in nature, such as criminal paternity. When a woman says or testifies that because of rape she gave birth to a child, then the issue of filiation is a relevant issue. DNA can be inculpatory or exculpatory, as we have said. So the rule on DNA evidence, actually you can download it. It's AM number 06115SC. I've got a .pdf file here if you want to download it for me. The date of activity is the 15th of October 2007. And it applies to all pending cases. This is in section 13. So if a case is still in court, and there are, and I'll give you the list of requirements later on for a DNA testing order. If there is a pending case, no decision yet made, then one can use the rule to be able to request or apply for us, put a petition in for DNA testing. The scope can be criminal action, civil action, special proceedings, basically anything. Where DNA evidence is offered, used, or proposed to be offered or used. That's in section 1 of the rule. So there are many different parameters, requirements for the application for DNA testing order, but I've highlighted the most relevant here. First of all, that a biological sample exists that is relevant to the case. So one limitation, and we're saying this up front, one limitation in DNA testing is that we can only test cases where biological samples exist. So for example, if a child says that she has been assaulted or she's been repeatedly raped by her father, but no medical examination was done, no sample was collected from her within 3 days post-contact, then DNA testing will not be available for her. There is no biological sample. Also the same thing if there is a, I've been discussing with the lawyers based in the US. They do a lot of video busts. IJM, International Justice. Okay. They do a lot of the, videoke bars, supposedly just videoke, but there are other things happening there. Instances, there are minors in the area. However, one challenge that I pose to them is when there is a bust, when the police raids, do they do a crime scene investigation? Do they collect whatever samples are there so that we can do DNA testing, or they just gather the women and the children and then the guys, take them to jail, and what happens next? So unless samples are collected at the crime scene to link the potential perpetrator, then DNA testing will not be for you, or cannot be done. So the DNA test has the scientific potential to produce new information that is relevant to the proper resolution of the case. Now, when I discuss this with the lawyers, of course, we know there are biological samples once collected, if they are biological samples, the relevance of those samples will have to be proven or argued by the lawyers themselves. So here we're looking at 3 different panels of expertise. One is your scene of the crime officers and people that directly deal with the people after the crime scene had been handled. Second would be the forensic scientists who will be doing the potential DNA tests. And third would be the lawyers to actually know how to argue the relevance of a biological sample in that particular case. Actually, there are 4. I forgot to say the medical allied professionals. You know, when there are busts like that or investigations dealing with children and women who are, well, humans, then dealing with bodies, then the pathologists or a medical legal officer has to come in. And therefore that is another expertise if samples are properly collected. We've done some work with the Child Protection Unit under the leadership of Dr. Bernadette Madrid. We've done over 156 cases of children that had gone to CPU, the CPU network, and we've published data that of those 156 cases we've done, and I'll show you some of them later on. But out of those 156 cases of female children, we found 63% of those cases had male DNA in the internal vaginal parts of the children as young as 2 years old. So they were powerful pieces of evidence that could have been used in court. There's another challenge in having to use them in court, but those are very powerful pieces of evidence. All right. Requirements for post-conviction DNA testing. If there is anything that's relevant, again, post-conviction can be done. Okay. Now, the assessment of the probability value of DNA evidence, and this is section 7. Here, there are 4 main requirements. First of all, the chain of custody, the DNA testing methodology, the forensic DNA laboratory, reliability of the testing results. All of this has to be assessed in court in order for the probability value of DNA evidence to be accepted. Of the 4, the main argument that you've got would be the chain of custody. Why? Because you are the ones, this group I guess, and also the scene of the crime officers, the medical, you are the ones at the forefront. My role as a forensic DNA scientist, I don't get to see the children very much, if at all. So, for example, for the one, I'm not trained, I'm not an expert in children issues, so I don't even attempt. So, for example, in the work that we've done with Dr. Madrid, the 156 cases, I didn't see any of those children. But the social workers, the child experts that have been trained by CPU, they are the ones who collected the samples. And then I am second in line in the factory, discuss with them what the case was. Of course, there was consent from the parents, etc., from the legal guardians of the children. And then, of course, we did a proper chain of custody and we did the analysis. But at the forefront here, and that is where I've testified a lot of times already, this is where the defense will try to break the chain of custody. So it's very clear if your group wants to do this, and we've got an existing memorandum of agreement with the Department of Social Welfare and Development, we've got an existing memorandum of agreement with the Department of Justice. In this situation and working with women's groups and with scene of the crime officers, this is something that we really have to operationalize, the chain of custody. Once it gets into my lab, we've got it all streamlined. We've got chain of custodies, we've testified in court, we have it operational. This one, we have not been able to do this because of diversity in the people in the front line. So that's something that maybe we could discuss amongst yourselves. But we are able to help provide principles of what chain of custody should be done. In actuality, I'm testifying on a case, and I can't talk about the case, but I'm testifying on a case, and I think the data is good, but there are things beyond my control in the chain of custody where I think it could lose. I hope it doesn't, but if they see it, if the other party sees it, I have no way of bringing it, of covering it up. I don't cover up, so that's important. Okay, evaluating DNA testing results. This is in section 9. First of all, the DNA testing results are evaluated based on the weight of matching DNA evidence or the relevance of mismatching DNA evidence. So for example, and you'll see this in the second part of the presentation when I talk about DNA evidence. When there is sample, for example, a body of a child, sexual assault case involving a child victim, there's a sample that's collected from her that is not hers. What we normally do is, as a first step, if the victim is female, we look for the male DNA that's found in her body. There is no other explanation, and there are male-specific DNA, we'll talk about it later, but there is a population of DNA that is only found in males. When we're dealing with female victims, we look for the presence of male DNA in her body. If that is positive, then that's already a big indication that there was contact, particularly in the intimate parts of her body, there is contact there. Now, with that DNA profile that is non-victim, we can then compare that with a suspect. For example, if the child says it was the neighbor that did this, then there's a court order, neighbor provides a sample, we compare the DNA profile non-victim from the child versus the DNA profile of the neighbor. If there is a match, then we evaluate the weight of the match. And what do you mean by evaluate the weight of the match? This would be a little bit clearer in the second part, but you know that there are some DNA that we've got. We said that we've got, humans, we share different DNA gene types, or what we call different characteristics. Although the totality of our DNA is distinct per person, there are certain characteristics that we do share. For example, in the Philippines, and I guess you're not included there, in the Philippines, 95 or 99% of Filipinos have black hair as a characteristic. That's in Asia also. So if we compare the characteristics, except if those dye their hair, you know, but genetically you still have black hair as your trait. Okay. Or those people that have lost their hair because of advanced age, but they still have the DNA for black hair. So essentially, if we use that as a DNA for comparison between non-victim DNA and that of the suspect, it actually is not a very good choice because it does not give you any additional information except that we have black hair. So those types of DNA markers or genes are not selected for identification because that will not be informative. So what we do in forensic DNA laboratories, and in fact, the U.S. Federal Bureau of Investigations have suggested what they call the CODIS markers. When you watch CSI, sometimes you hear this words, okay, send this to CODIS. CODIS is an abbreviation for Combined DNA Identification System, which is their standard 13 markers that they use as a first pass. These are highly polymorphic, highly variable DNA, unlike the DNA for hair color, which can be used to differentiate between two persons. Now, when I say it's a first pass, because many laboratories now don't just use 13 DNA markers. In our lab, we screen minimum about 22. For some of our Y chromosome, we test about 20. So the higher number of DNA markers you test, the higher is the power of discrimination of the whole panel of DNA that one is able to test. And therefore, there is less likelihood of what we call a random match. Now, a random match, you will see a bit later. What's a random match? You said, Doctora, that the DNA of two persons will never be the same unless you're identical twins. Yes, we will never be the same. But that means a totality of your 3 billion base pairs. And we do not test the 3 billion. We only select highly polymorphic. It's so expensive. You cannot do all of the DNA of a person. So there is a limitation of the current panel of DNA markers that we use, which is can be 13, 20, 23, etc. that could potentially have a random match. Highly unlikely, but it could be. So one needs to evaluate whether the type of DNA that was found in the victim that is not hers and that of the suspect may be attributed to a random match. So we have to do some statistics, which is too complicated to explain, and I think you'll be so bored to listen to it. But we need to come up with some of those numbers, such as likelihood ratios, probability of paternity, matching random match probabilities, etc. So we give a certain evaluation of the weight of the matching DNA evidence, plus the complexity. And here in the Philippines, it's a complexity that many times the child is violated by somebody that is related to her by blood. So that has to be also taken into the calculation. Or that, and we've had a case, and this is, I'm sure you've heard worse cases, but for us scientists, when we read the sheets given to us, we kind of realize we need to take the technology further. We had one case where the two suspects were father and son of his sister. The victim is the child and the sister. So the complexity of the entire thing was we had to take that into account when we did our match. So evaluation of weight of DNA evidence, we do this, we do a lot of stats, we consider what information was provided to us. And this is the reason why if we are going to work together, we will be, English, makulit. Why? Because we need to know exactly how related, to the best of our ability, is the suspect from the victim. Because we need to make adjustments for those. Thank you. We need to make adjustments for those. So we do the stats here. Now, in the second level, it could be a match, but at the same time, the non-victim DNA may not necessarily match that of the suspect. But it doesn't necessarily mean the suspect is innocent. So one has to again evaluate the relevance. Why? And I've just finished, one student of mine just finished his thesis with me, and he evaluated the use of condom as a physical barrier to prevent everything, of course, ethics. But he evaluated, really there was point of contact and it was part of the research, but evaluated how a condom could provide a physical barrier separating the DNA of a man and the DNA of the penetrating and the recipient. That was how he termed it. And it actually does separate to a large extent. Not 100%, but in some of his samples, they were total barriers. In other words, if a child was really violated by this person, and this person violated her, actually wore a condom.
That's what I was thinking.
Therefore, it would not match. And then we've done not so much for the younger ones, but we've discovered also with the older ones, and this is not we, Dr. Madrid tells us, that sometimes, I guess you encounter this, a 15-year-old will not tell the social worker that she's had contact with her boyfriend because, of course, there are parental issues, etc. So she might have had sex, consensual, with another teenager, another person, but this act that she has been saying is really rape. She did not agree to this contact. The other one, yes, she did. So what could happen, and this has to be evaluated based on the testimony, the circumstances, etc., is that if a girl had sex with her boyfriend, a teenager had sex with her boyfriend, consensual, no problem. Well, for her, no problem. And then within 3 days, she was assaulted or raped by another guy who wore a condom. Then the mismatch of the evidence found in her body does not prove or disprove the fact of her testimony. It just says that it did not match. But then we have to give all that during the testimony, because the defense will make a big hole in the DNA evidence saying that he should be excluded because she didn't say everything. So again, it's not as easy as it seems. So a lot of this, when we talk to the lawyers, to the social workers, we try to get all the narratives even before we do the DNA tests. Why? Because it allows us to present the evidence, to be able to evaluate the evidence without bias. You know, the totality of the entire scenario. And so part of the interview, and we've taught Dr. Madrid and Dr. Merly Tan, they are the ones teaching now the doctors in their CPU network. We went through with them a lot of the forms that we requested to be included in the kits for them to be able to explain to the medical doctors why these are necessary. Results of DNA testing in light of the totality of other evidence presented, we've discussed that already. And then in the situation of paternity, DNA results that exclude putative parents shall be conclusive proof of non-paternity. This is more for, I guess, women's rights, not so much of the, but one thing that the rule on DNA evidence has done, and this we fought very hard to be able to get it in, is that in our experience, we've experienced a lot of cases in family courts. When we wait for our own cases to be presented, you hear of a lot of the women trying to get child support for their children, whether illegitimate or, well, usually illegitimate children. And the burden of proof in those situations lie on the women. You have to prove that you had contact, that there was no other man, etc. And prior to DNA testing, a lot of that was testimonial evidence. And it can be whole spectrum, and it actually, I want to raise my hand sometimes to say, may I be excused and go outside, because some of the testimonies are so invasive, even to the description of the physical features of a man's body to prove that she saw them, she saw it. And it's all for public, consumption, which of course some public do not want to consume. But we are there, we're not even asked to leave. Or even the child is there, you have to look at the ears because the ears are the same as the ears of the father, etc., etc. So a lot of this we've seen. This was the situation of the courts before, if they did not use DNA. Or the receipts of the apartment, the receipts of the hospital, the love letters, the photos, those were the evidences that were used to increase the possibility of the woman winning the case for child support. However, with the rule on DNA evidence, we discussed this with the Philippine Judicial Academy, and then we presented this. We said we've got data to show that once the probability of paternity reaches 99.9%, we do all the DNA tests, alleged father, mother, and child. A child's DNA, half of that comes from his father or her father, the other half comes from her father or mother. We are able to trace what is mother and what is father. So if the DNA of a child does not exclude a man from being the father, we can trace everything, mother and father, then the man is not excluded from being the alleged father. Here it says that the result of excluded parent shall be conclusive. If the child has DNA of the father, that has DNA that cannot be traced back to the father, then that's conclusive. There has to be another man. There has to be somebody else that gave that DNA to him. Conclusive. End of story, finish. However, if you cannot exclude the DNA of the child matches that of the alleged father, then we do our statistics. Again, matching DNA evidence. Now, some statistics, depending on whether we're dealing with deficient cases or challenge samples, some more complexities, etc. If the probability of paternity does not reach 99.9%, then the Supreme Court has agreed that it will treat that probability as a corroborative evidence of paternity. It will not exclude, it does not exclude, because there's no mismatch. However, it is still insufficient to stand on its own. However, if the probability of paternity reaches 99.9% or greater, which is what we're getting, now we're testing 20 markers, our statistics are 99.99999967534, whatever, then it becomes disputable presumption of paternity. And the word presumption is a very important word. Why? Because the court will now presume that the man is a alleged father. The burden of proof now shifts from the woman to the man. You prove that you have a twin. Where is the twin? You prove that you do not produce sperm, where is your medical examination? You prove that there was somebody else, then you bring him here and we will do the DNA test. Otherwise, you pay the child support. End of case. So really, this is why this is in our view is very strong. Actually, it has helped a lot of the courts in terms of the speed by which paternity cases or filiation cases can be decided in